Well, hello, everyone. It's time for HR Office Hours. I'm Sandy Zannino. I'm here with my friend, Brad deBeaubien.
Good to see you, Sandy.
It's good to see you too, Brad, bright and early. Today we've been talking about a lot of interesting things that have been happening in HR news, I guess you could say.
Yep.
Today, though, we're going to talk about something I haven't heard too much early I think at the end of the year, maybe in December, there was some hoopla about arbitration agreements. So can I give you my take and then
that's how I was gonna proceed, was say, because this comes up from time to time. I have a lot of thoughts on them, but I want to hear kind of where you are with arbitration agreements, what you think about them, what you like, what you don't like, what you don't know, and then we'll go from there.
Okay. So my first experience with arbitration was probably more than 15 years ago. And the organization that I worked with, it's what I came to understand is that it's an agreement, right? And for any agreement, you get something for signing this agreement, right? And in this case, if a company decides they're going to roll out arbitration, which to my understanding is just an alternate way of resolving a dispute, right? It's still kind of it's still a court. It's just not you're waiving your right when you sign an arbitration. You are waiving your right to a jury of your peers, is what I understand.
Yeah. So let me just jump in with clarify, and then we'll go. Yes, you're certainly waiving a right to a jury. It's sort of an alternative venue for dispute resolution. So you're not really in a court either. I mean, you're right. To the casual observer, it probably looks procedurally a lot like a court, right? There's a person or a panel of people that are the decision makers, kind of playing the role of the judge. There's lawyers typically on each side. There are witnesses called in the procedure. There's probably a reporter taking, stuff down. Lawyers make legal arguments. They ask witnesses questions. And at the end of the day, the arbitrator or arbitrators are going to make a decision like a judge would. There's definitely not a jury, but as opposed to a judge that was either appointed by, elected officials or may have been elected themselves, depending on the jurisdiction, an arbitrator or arbitrators who make decisions it's a private setting, and the parties are paying the freight for those people. So you're mostly right, but I just want to make those clarifications.
Isn't it often less expensive though than a big court proceeding for both sides?
I think that's a common misperception. And I think that's maybe a thing that's evolved. Certainly 20 years ago, I think everybody believed that arbitration ultimately, even though you had to pay the judge as opposed to a court where you don't have to pay extra for that, right? That's what your tax dollars pay for. Even though you were paying for an arbitrator, the thinking, 15, 20, 30 years ago was it's going to be ultimately quicker because it's going to be more efficient, and it's going to be so it's going to be cheaper and it's going to be faster. And that was, the business community really latched onto that. Like, yeah, we're willing to pay a little something because in the end of the day, we're going to save money and it's going to go quickly. We don't have time for this government bureaucracy business. I think those have both sort of changed. The courts, notwithstanding the COVID backlogs that a lot of courts were dealing with and still are on some level, having gotten through the Great Recession backlog of foreclosure cases, a lot of courts can move pretty quickly. And I think the cost is arbitrations can get just as gnarly and have as many issues and document production issues, et cetera, as a proceeding in a court of law would have. So the notion that you're going to save money, I think that's probably a wash. And then when you factor in the cost of one or maybe even three arbitrators, typically you have either one or three. You want an odd number so that you have consensus or a majority. Those people typically probably get $300 to $1,000 per hour for every hour they spend on, working up the case, making decisions, reading, blah, 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 blah. They're like lawyers, and lawyer fees run the gamut from, probably 300 to 1,000. And there are certainly lawyers that charge less, and there are certainly some lawyers that charge more than that. But I think that's probably a pretty fair wide band. So the cost does add up with arbitration. And I think at the end of the day, the notion that it may be cheaper is misguided.
Well, I think that's probably maybe one of the most important points of this episode, right? Because I think that is one of the big reasons why why organizations decide to have an arbitration agreement. I mean, I know in a lot of contracts, there'll be an arbitration clause, that if, so I think that that's really an interesting point. And
yeah, and I mean, for point of reference, we generally don't put them in. And if we inherit a client's contract that they want us to look at or update, whether it's a form of employment agreement or restrictive covenant agreement or a standalone, some other standalone agreement that has a dispute resolution, we'll typically have a counseling session with them about, hey, I see you've got arbitration in here. Our perspective is, basically all the things I just said, and I'll let them make a decision. And sometimes they say yes, but I think it's a more business friendly forum. Whether that's true, that's probably slightly true. But I don't know that it's enough to justify, going that route. We oftentimes counsel clients. And the other thing to consider is in employment law, and this kind of dovetails with something else we were talking about, right? Non-competes are a major factor. If you're litigating a non-compete, oftentimes, or any kind of restrictive covenant or non-solicit confidentiality where somebody stole your trade secrets or other confidential information, the relief that you're most interested in typically is, let me get an injunction that says tomorrow you can't go to that new job that you got, or you've got to deliver all of these information that you stole back to us immediately. An arbitrator can't enter an injunction that has the full weight and authority that a court would. You'd have to go to a court and get them to sort of sign off on that and to make it fully enforceable anyway. So a big chunk of what typically gets litigated in the employment context is injunction actions, and the relief is not as expedient, is not as full and robust as you would get if you just started in a court of law. So again, for all of those reasons, we counsel clients away from use of arbitration clauses.
So an arbitration agreement can actually hinder the company's strategy when there is some other thing that they need to litigate.
Yeah, particularly if it's a restrictive covenant. And I wouldn't say hinders, maybe not the right word, but well, maybe it certainly is not as
slows it down.
Relief. Yeah, it slows it down. It bogs it down with a little bit more process than would otherwise be necessary if you just started in a court of law and you had a judge that could enter an injunction, in 2 days if the circumstances warranted it.
So I'm totally changing my mind. I'm based on this conversation, right? I'm changing my mind about arbitration agreements. I used to be a fan of a well-written arbitration agreement, right? Like I would always say, make sure you have your, because things have been updated. Make sure you have it looked at by your, your counsel on a at least biannual basis. And I know that there was some hoopla about, well, not hoopla. I mean, I think, was it December? I don't know. Biden signed something where sexual harassment is no longer, you can't resolve that dispute through arbitration.
And that's sort of another thing I wanted to mention here is now what you've got is all these carve outs of things that can't be arbitrated anyway. So it's like, well, what are we, it's sort of counterproductive for our injunctive relief if the business needs that. We're legally barred from, bringing certain or defending, having adjudicated certain types of sexual harassment claims in this context anyway. And I think for justice, that's a win, right? To not have those be in the, business friendly forum, but let a court of law decide those. I think there's also a trend. We don't have legislation on this yet, although it's been talked about that, a lot of discrimination claims aren't going to be subject to arbitration. They're going to have to be done in courts. And that's going to sort of gut the whole notion of why arbitration would be worthwhile. And in certain states, you've already got laws that are going in that direction. California has its whole private attorney general act. And I'm not a California lawyer, so I don't, claim to understand the full implications of that. But there's a bunch of ramifications about things. And I think there's a lot of limits in states like California already on what can be subject to arbitration. So, particularly if you're a multi-state employer, you've got all these differences that you got to be keeping track of. And there's already, Lord knows enough of those that you have to be mindful of as a multi-state employer that where an arbitration agreement is or is not enforceable. It's just kind of another variable. And maybe you're, given all the other things we've talked about, probably something you want to stay away from.
So if there's anybody watching who is either considering arbitration or has an arbitration agreement and needs to talk with someone about it, how can we contact you everybody knows how to contact me. You can find all of my information is in my profile, and I'll put it in the comments. You know, but Brad, I know that there's going to be some people, some employers watching that are wondering, maybe I shouldn't have arbitration, especially in automotive, right? If any of my dealer friends are out there, there's a lot of multi-state that you bring up, right? So you have to be careful. All of your agreements need to comply with whatever state you are operating in.
Exactly. Yeah.
So
So my LinkedIn pro, I'm Brad deBeaubien. You find me on LinkedIn or on the Shoemaker website, and happy to talk with anybody about that. But you're right. It's just, it's the kind of thing that if, you know, you drafted your forms 10 or 15 years ago and you thought, well, this is good, you know, I think probably a 5-year cycle at a minimum of dusting those things off and running them by your counsel and just saying, hey, do we still want to be doing these things, is a good habit to get into. And if it's been, you know, 10 or 15 years since you had anybody look at those forms, and you may have things like arbitration agreements buried in there, or, you know, heavens, we've talked about so many different things in the last, you know, couple of months, Sandy, where the law has moved, right? Those NLRB decisions about confidentiality and your severance agreements, about non-disparagement, right? I mean, there's real trouble there if you're not having somebody take a look at those forms. So a good idea to review those with your counsel, you know, on a periodic basis.
Yep. So thanks for watching, everybody. Join us next time for HR office hours, and we'll see you then.
Bye-bye.
Have a great day, Brad.
You too, Sandy.